Section 35 has definitely grown. The case law, like I said, there's been over 40 some odd cases, and so as one might expect, the law has grown from the first seed in the first case, where the court is really feeling its way around the issue of what does this section mean, to law in Canada, to, you know, almost 30 years later, where we have been following something that has been, I think, basically the way I think of it is the way Brian Slattery talks about it, that we've been creating a map of the world, basically, within Section 35, and we've been drawing out the major landforms and the different articulated areas of it. And for the most part right now, I think it's kind of mapped out, but it's taken us the better part of 30 years to do that. So the first big case that came didn't get to the court until 1990, and that's the Sparrow case. And really, that is the foundation on which everything else rests. Anybody who is doing Section 35 litigation, for every case you go to the court again, you go back and you read Sparrow again, because it is the case that set the tone for everything else. And that was when Chief Justice was Brian Dixon at the time. And he wrote extensively about what the different phrases in Section 35 mean. What does recognized and affirmed mean? Is a big discussion. And what does it set out by way of the relationship between Aboriginal peoples and government? And it's in Sparrow and Garin, the first big cases, although Garin's actually not a Section 35 case, but it's those two cases that really set out the idea that Aboriginal people are not in an adversarial relationship with the Crown, and the idea that recognition and affirmation is essentially places obligations on the Crown. I mean, affirming is not something you do by not doing anything, right? I mean, it is an obligation. So the idea that the Aboriginal and treaty rights of the Aboriginal peoples of Canada are hereby recognized and affirmed means that it has to mean something. It's not just a statement. It has to be. You have to put some flesh on those words, and so they did. And then the other part of that is, what does existing mean? You know, all of those things got fleshed out in Sparrow, and then it's basically taken off from then. We've had Aboriginal title cases. That was a harvesting case. We've had Aboriginal title cases. We've had cases that cross both, that are Section 35 cases and are charter cases. So they involve Section 15 as well. We've had quite a few of those equality cases. Those have tended to arise when there's a big project, like where different Aboriginal peoples want access to the same benefit, for example. So some of those cases or another one is the rights of Aboriginal people who don't live on reserves. Do they get to vote on reserve elections if they are living off reserve, but they're still members of the band? Up until the Corbière case, the government was able to treat, and bands were able to treat their very limited jurisdiction and say it was all bounded by the geographic boundaries of the reserve. And the Corbière case, the Supreme Court of Canada said, no. Aboriginal and treaty rights does not mean that you're bounded by this little tiny block of arbitrary land here. Those are your members, those are your people, you've got to look after them, you've got to deal with them. So those are all big principles of who the people are and how you would take a case to the court. The first Métis case, the Pauli case, is a finding in, that's not till 2003 by the Supreme Court of Canada, that Métis people are not just included in Section 35 as a freebie. I mean, they actually have Aboriginal rights and treaty rights as well, and that they exist as rights-bearing people in this country, and they've got to be treated like that. That has had a fundamental change for Métis people. Métis people like to say that until Pauli came down in 2003, they couldn't even get the janitor to talk to them in the federal government because they had been denying that they had any responsibility to talk to Métis people at all. And that changed on that day. Everything changed. So the idea that it's been evolving, that the case law is pushing the boundaries of how we look at Aboriginal peoples, how we look at them as peoples versus what the government has defined them as. Like, all of those things have been dealt with by the Supreme Court of Canada now. And so I would say we've got the foundations are pretty much laid. That doesn't mean that all the gray areas are figured out. There will be more litigation under Section 35. We still have no finding of Aboriginal title in this country from the Supreme Court of Canada. So that's clearly something that's got to be decided, and that is, there's a case coming up through BC right now, which I would hope they'll actually make a finding of Aboriginal title, but that's clearly a big missing piece of the puzzle that is not there yet.